Thank you very much for the invitation and for the kind introduction. I must at first apologize that I have no technical equipment. Besides that I came here, there is some difficult relationship between my technical capacities and the modern technique. So you can only hear me. And another introductory remark is that in addition to the title, which just of my lecture, The International Protection of Human Rights, I also had a subtitle. And the subtitle is to a certain extent important for my speech. The subtitle was and is no longer a human rights wall between states. No longer a human rights wall between states. And I thought whether this is a statement or is it a question. It can be both. No longer human rights wall between states. I would say it is legally a statement and in reality a question. Because I will explain this further. And if we now look to the texts, the legal texts on international law for the protection of human rights, we find innumerous texts, and you can in this book, which contains only texts on human rights in international law. Not all texts are in this book. There are many, many more. But the question is, how far does reality conform to these texts and obligations of the states? So I consider at first the legal framework. On the universal level, we find a great number of non-binding human rights pronouncements from the Universal Declaration of Human Rights of 1948 to certain respect, the source of all later texts. We find this Universal Declaration, and there are many other non-binding texts, for instance, in the Helsinki Declaration of 1974, and thereafter in this Organization for European Security and Cooperation, there have been adopted many non-binding legal texts. But we have even more binding treaties, and this starts again in the year 1945 in the United Nations Charter, which already contained very important human rights obligations. I quote, in the preamble of the Charter, it is said, "We, the peoples of the United Nations, determined to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women." End of the quotation. Article 55 of the Charter underlines once more the promotion of, and now I quote again, "universal respect for and the observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion." End of the quotation. 192 states, nearly all existing states, are members of the United Nations Organization and have adopted the Charter, including all Arab and Muslim states. Remember, this Charter underlines the equal rights of men and women and excludes any discrimination based on sex. Many other treaties with universal validity protect human rights. The two United Nations covenants adopted in 1966 and in force since 1976. Other conventions prohibit genocide, we have just heard, or end racial discrimination. Even still others provide additional protection for women, for children. Besides these numerous documents and binding treaties, the prevailing opinion among international lawyers is that also customary international law protects the individual against the most severe human rights violations, like torture and inhuman treatment or imprisonment without due process of law. Even the charter, even the character of jus cogens is attributed to some human rights guarantees. If we take all these texts together, we recognize a universal network of human rights guarantees. Nevertheless, if certain governments are criticized for human rights violations by other governments, by international organizations or non-governmental institutions, a standard defense is the insistence that the criticized measures are internal affairs of the states concerned, and that any outside interference is illegal. Is this correct? It may have been correct under international law 70 or 80 years ago. But in the 21st century, human rights violations are no longer internal matters. The same is true if the Chinese government condemns the Peace Nobel Prize for a Chinese human rights activist as an interference into domestic affairs. The insistence by third states and other actors on the respect of human rights is in conformity with present-day international law. These remarks concern only verbal, diplomatic criticism, protests, and other peaceful measures. It is beyond this report whether also the so-called humanitarian intervention is permitted. That means forceful protection of human rights across state boundaries. This difficult problem cannot be discussed at this moment. Coming back to the network of human rights guarantees in public international law of our time, the question remains whether these guarantees are respected and implemented. The answer is probably to a considerable extent negative. I'm convinced that many events in Guantanamo Bay, as an example, are in violation of international human rights guarantees. The same holds true for Russian acts in Chechnya, for some Chinese acts in Tibet, and others. We have heard yesterday something about Israeli, the area where Israeli forces are and settlers. If all the texts and guarantees which exist were respected, we would live in a better world than we live in reality. But the balance is not altogether negative. On the universal level, we find monitoring bodies which supervise the implementation of the relevant treaties. Committees are created in the areas of racial discrimination, protection of women, of children. Some of the bodies do valuable work. Others, like the United Nations Human Rights Commission, have more an alibi function. A central problem of all these institutions is the absence of effective supervisory competencies and the absence of binding decision-making powers. It is not only the absence of effective supervisory bodies, but also the lack of a common and uniform understanding of the relevant texts and the essence of human rights. Muslim states, at least their governments, understand the equality of sexes in an entirely different way than Western states. Authoritarian governments all over the world often pay human rights only a lip service. They ratify the human rights treaties, but they have no interest in their implementation. It is also a standard argument that social rights are more important than traditional human rights. This is a strange argument. The truth is, I think, that the absence of hunger and the absence of torture are equally important. My overall result is that the international protection of human rights has reached a level which is impressive and is based on numerous binding treaties, but the reality is not always in line with these texts. International control and supervision is still needed, but it is not available to the required extent. No legal wall exists between states in the area of human rights, but a mental and factual wall still often exists. Let me now turn to the regional developments. These regional human rights, three regional human rights conventions and courts have to be mentioned: a convention and court for Europe, a convention and court for the Americas, a convention and court for Africa. The African Convention on Human and People's Rights, this is the official title, the so-called Banjul Charter, dates from 1981 and has been elaborated and adopted under the umbrella of the African Union. This convention provides for an African court for an African Human Rights Commission, and only a few years ago a court has been added. The African Court for the Protection of Human Rights has rendered the first judgment in the year 2009. It is to be hoped that the African developments contribute to an effective protection in that continent, but it is too early to draw a solid balance. The American Convention on Human Rights is much older. It exists since 1969 and is a product of the Organization of American States. An Inter-American Commission and an Inter-American Court of Human Rights have produced rich jurisprudence, which can be mentioned here only briefly. The court exists since 1979 and has adopted a considerable number of far-reaching judgments and also of advisory opinions. The convention, the American Convention, and the organs provided then seem to be important factors in the human rights area in the Western Hemisphere. We now concentrate on European developments and my own experience in that European court. As it is well known, Europe was the battlefield of massive and cruel human rights violations in the first half of the 20th century. The German Nazi government was in first line responsible for the crimes and the Holocaust. At the end of the Second World War, all sides condemned human rights violations, but the ways and methods to avoid and combat the violations were different. The so-called Iron Curtain separated East and West, and the human rights concepts were totally different on both sides of this curtain. In Western Europe, the Council of Europe came into existence in 1949-1950, and one of its first and famous achievements was the adoption of the European Convention on Human Rights in 1950, and this convention came into force as a binding treaty in 1953, more than half a century ago. In the following decades, this convention had a considerable influence on the human rights situation in the western part of Europe. I will come back to some details later. At first, I jump over nearly 40 years. Around 1990, the communist regimes in Central and Eastern Europe broke down. And one of the first international steps of the majority of the former communist states was the application for membership in the Council of Europe. And a condition for this membership was the adoption of the European Convention on Human Rights and its control institutions. One of the consequences was that in the late 1990s, during the last years of my membership in the European Court of Human Rights, I had the pleasure to cooperate in the court with new judges coming from Hungary, Poland, the Baltic states, and many other states, and finally also since 1998 from Russia. In a few years, in the 1990s, the human rights situation in Europe had completely changed. A uniform text and common institutions had come into existence. Compared with 1981, the beginning of my membership in the court, when 21 states were members of the Council of Europe and parties to the European Convention on Human Rights, the number of parties has doubled. 47 states are now bound by the convention and the judgments in Strasbourg, of the court in Strasbourg. Only one European state remains outside the convention system, that is Belarus, White Russia. I must leave aside the special situation of Kosovo, where in substance, at least, I think the European Convention is also respected. And I leave also aside the Vatican State, since it doesn't make sense to discuss this situation here. In 2004, after the end of the Milosevic regime, also Serbia became a party to the Human Rights Convention, and Montenegro is also a party. At present, around 800 million individuals in 47 states have the right to submit a complaint to the European Court of Human Rights in Strasbourg, and more than 40,000 do this annually. The convention is even applicable beyond the boundaries of Europe. This applies to the non-European parts of states which are members of the Council of Europe, especially Turkey, and also Russia, as I said already. So that means that also citizens of Vladivostok can apply to the court in Strasbourg, and the same is true for citizens in Anatolia, etc. In many cases have come to Strasbourg from these areas. Incidentally, in March of this year, the Chamber of the Strasbourg Court has even decided that the convention is, at least in certain situations, applicable even in Afghanistan. In that case, the court decided that a person cannot be surrendered by British authorities in Afghanistan to Afghanistan institutions if this person faces capital punishment when surrendered. Also, in other former cases, since 1989, the court decided that the European Convention prohibits extradition and expulsion to non-European states if an individual faces torture or inhuman treatment in that third state. There are still some open problems concerning extraterritorial effects of the European Convention, but it is beyond doubt that certain effects of this kind do exist. The European system for the protection of human rights is at present in a certain danger, but the danger stems not from the opposition of the states parties to the system, but from the success of the same system. So many citizens of European states submit their applications to the court that the court is more and more unable to keep pace with the incoming applications. Let me give you a few statistical figures. A few weeks ago, at the end of September of this year, nearly 140,000 applications were pending in Strasbourg. it cannot be excluded that each year the backlog of undecided applications increases by between 10 and 20,000 complaints. Some other figures for that year, for the last year, for 2009. More than 13,000 applications were submitted last year against Russia. More than 4,000 applications against the following states: Poland, Romania, Turkey, Ukraine. These and other figures say nothing in respect of the gravity of the alleged human rights violations, but nevertheless they must be scrutinized. In the end, more than 90% of all applications are declared inadmissible, but they must be scrutinized. And the 47 judges in Strasbourg, each state has the right to nominate a judge, and their collaborators. The number of collaborators of the Human Rights Courts in Strasbourg is more than 500. They must decide on the admissibility and eventually on the merits of each case. They must find out which cases need further investigation. The whole system is, as I said, in danger. It is overwhelmed by the number of applications. Some reforms are underway, and it is hoped that these reforms are successful. One encouraging factor is that, as far as I can see, nobody applies or argues for an abolition of the whole system. The international protection of human rights seems to remain a firm element in our time. Let me add that also the European Union, which has its own Charter of Human Rights, has in addition solemnly declared that it will soon adhere to the Strasbourg human rights system. I would like to add some some remarks concerning the states which are mainly responsible for the great number of pending applications in Strasbourg. I have already mentioned a few numbers. I will add a few one. The figures are here not mentioned for arguing that these states have a bad human rights standard, but only to show the geographical distribution of cases. I take the figures from of the end of last year, the year 2009. At that time, nearly 80% of all cases, the 140,000 cases, nearly 80% concerned 10 states. All the other 37 states, members of the system, counted together only 23% of the applications. The 10 states were Russia, with more than 33,000 pending applications, Turkey with 10,000, Ukraine with also 10,000, Romania with 9,800, Italy with more than 7,000, Poland with 4,700, Georgia with 4,000, Moldova with 3,300, Serbia with 3,200, and Slovenia with 3,200 applications. With the exception of Italy, where the length of domestic court proceedings has always played a big role, all states with more than 3,000 pending applications are located in eastern and southeastern parts of Europe, including Turkey. The geographical distribution of cases has several reasons. I can only mention a few of them. In Russia and Turkey, minority problems play a certain role, but also problems concern the judicial system, the independence and proceedings of courts. Also, corruption in state administration may be relevant. What is also interesting is that in all these states, the Strasbourg system seems to be well known at least in some circles, what is very important to be that this is known among lawyers, then the number of cases increases drastically when the lawyers know where they have another field where they can act. It is also true that potential victims sometimes get help from non-governmental organizations in other countries. Amnesty International, Human Rights Watch, and similar institutions. Governments normally don't like these outside help, and we have heard that Russia has taken some measures to make it more difficult for for institutions coming from outside. But I consider that these helps are useful and even necessary, since the victims often belong to the poorest sectors of the population. If a poor person in Anatolia or Chechnya is the victim of any human rights violation, she is unable to invoke the rights effectively without help. I didn't look on my clock at the beginning. I think a few minutes I still have. I would like to make a few remarks also in respect of the implementation of the European Convention on Human Rights. The balance has been until now good, but I'm not convinced that it will remain so. But there exists a certain control machinery. It is foreseen in the European Convention on Human Rights that the judgments are also sent to the Committee of Ministers of the Council of Europe, and that this committee supervises the execution of the judgments. That means in practice that not the ministers, but some lower and in this respect also more effective persons are, with the help of the Council of Europe Secretariat, they ask the states, what have you done in implementing the decision? And the states must justify what they have done. And this is so important because it's not only the violation itself, but also the consequences. Sometimes laws must be changed. For instance, several decades ago, Belgium had, in consequence of the Marx judgment, Marx has nothing to do with Karl Marx. It's spelled differently, and also it was concerned with a young lady. But Belgium had to change its family law because the Strasbourg court had decided that the treatment of unmarried mothers in the family law of Belgium was incompatible with the European Convention on Human Rights, and so it was necessary to change the law. It took some time, but finally it was done. And if I'm correctly informed, Turkey even once changed its constitution in respect of the composition of military tribunals, because the Strasbourg court decided, it was still at my time, decided that in this case the composition of the military tribunal did not guarantee the independence of some members. There were some high officers in the tribunal which were not entirely independent, and the Strasbourg court decided that this is not compatible, and Turkey accepted this and changed the constitution. So there is a great, or I would say all states until now have adopted, not only have respected the judgments, but normally are also prepared to do all what they must do. This is not concerned, as I already said, this does not concern only the individual case, but also some general measures are often necessary. I would like to conclude what is the vision for the future. An idealist could say, in some time in the future, no human rights court should still exist. It should be abolished under two conditions. At first, there are no longer grave human rights violations, but the internal situation is in conformity with the human rights guarantees. And the second condition is that on the national level, there exist enough courts with enough competencies to correct eventual violations of human rights. If these two conditions are met, there is no longer any need for an international human rights court. And I hope that many of these in this room will live when this vision becomes reality. There are no indications that this will be in the near future. Thank you.
Thank you very much, Dr. Bernhardt. Okay, we have an opportunity for some questions for Dr. Bernhardt. I suggest we'll group them together.
Thank you very much, Dr. Bernhardt. I'll be brief. I'll actually use the ICD 20-second speaking time, so I'll go straight to the point. My question is, while the European Court for Human Rights has been effective in protecting human rights for its citizens, the fact remains that there are still human rights violations in Europe. Currently, there are over 270 detention camps throughout Europe for asylum seekers and illegal immigrants, many of which fall well below the international standards, as many of these people in these centers are denied basic medical care, food, and are subject to beatings and so on. Many state governments do not want to acknowledge this, but it is a fact. So how can the EU promote itself on the global stage as a vigilant defender of human rights when such occurrences take place within its own border? Thank you.
Should I ask immediately or what?
Yeah, thank you. I would just like to add on to what you just said, and that my question is basically that if we have such cases, what does the EU do apart from issuing a certificate of incompatibility? Yeah.
I didn't understand that.
What else does the EU do if states don't obey certain rules which are mentioned in the European Convention of Human Rights, such as the treatment of refugees? What else can the EU do to bind states apart from issuing a certificate of incompatibility with the ECHR? Thank you.
Final question.
Hello, I'm Dominika. I'm from Austria. My question is more technical because I think that sometimes people might be confused, because when talking about the European Union, then the Charter of Fundamental Rights of the EU, and then the work the court in Strasbourg does. And you also mentioned that the EU will soon switch to the Strasbourg system. Could you explain this a little bit more, and how the ECJ and the court in Strasbourg cooperate? Just clarify a little bit. Thank you, as expert.
Thank you for the question. I could add another lecture since the questions are very interesting, very important, but I must be brief. At first, violations in Europe. It's a simple fact that only, and beyond Europe, only states parties to the convention are bound by the convention. So, and only for the time after they had ratified the convention. This means that the Strasbourg court is unable to deal with the terrible events we have heard during these days. And there are a few situations where so-called continuing violations, which have started in the past and are continuing today, can be brought under certain circumstances under the convention. But in principle, what has happened in communist states or any other states before they ratified the European Convention on Human Rights cannot be scrutinized in Strasbourg. And therefore, Srebrenica and all these other terrible events cannot be scrutinized by the Strasbourg institution. It is not a court for the past, but for the present and for the future. This is maybe unfortunate, but the court cannot do, in my view, otherwise. So I have the impression that the detention camps in Europe, which have been mentioned by the first person putting questions, I hope that there are no detention camps of this kind in the present. It's clear that in the prisons are also persons who are suspected of having committed some crimes, and they can be kept in, but I wouldn't call this detention camp, but detention camp probably can mean only camps where persons are kept like in Guantanamo or in some other camps without any judicial control, without finally also a judgment. So I hope that at present no such detention camps exist in Europe, and if they would exist, the inhabitants could, the inmates could apply to Strasbourg. And may I mention that also recently the court in Strasbourg again decided that a state violates the convention if it does not forward petitions from prison to Strasbourg. Thus, the states are obliged to cooperate with the Strasbourg institution. A most difficult question is the relationship between the European Union and the Council of Europe. You might know that from the 47 member states of the Council of Europe, 27 are members of the European Union. All these 27 members of the European Union are also members of the Council of Europe. And for many years, I have had the first discussion on this, on the relationship between the European Union, or at that time, European Economic Community, with the Council of Europe and the Strasbourg Convention. And this discussion is now about 40 years old. And no solution, no clear solution has been found until now. As you know, the European Union has adopted this Charter of Basic Rights, and this is, since the Lisbon Treaty, is also now binding law. And besides that, the European Union has expressly promised in its treaty that it will adhere to the European Convention on Human Rights. This adherence might be of relevance only for acts of the European unity organs. The relationship is not entirely clear, but it is clear that there must some mutual cooperation and respect, and until now, this mutual cooperation and respect exists only on an informal basis. The judges are coming together. They also read the judgments of the other side, and sometimes they discuss the problems, but a clear solution is not yet found. It is for the competent lawyers to find a solution from the question whether there should be in Strasbourg also a judge from the European Union and many other things. What's about who is which court might be the higher institution? Probably in human rights questions, the Strasbourg court. In other questions, the Strasbourg court is not competent, but only there are still some number of problems, but there is enough work for future lawyers to do.
An appropriate note to finish on. Dr. Bernhardt, we'll have an opportunity to hear more from you shortly in the panel discussion, but I'd like to take this opportunity to say thank you very much for your speech this evening.